The core document is the Social Security Act of 1935 as amended. The operative phrase, of course, is as amended, for in the long history of this program, it has been changed many times, changed by Congress, and also changed by Congress under the guidance of the Supreme Court. The following brief account provides some of the highlights of that history. The first period of this history we might call the foundation years. This period begins before congressional enactment and runs for a good number of years after. It was clear to those who turned to framing federal social legislation in 1933 and 1934 that such legislation posed serious constitutional questions. The novelty of the federal government's moving into such areas, combined with the necessity for federal inducement and review of state legislation and administrative action, posed serious issues. Unemployment compensation drew first attention. A few states already had unemployment compensation programs in place, financed on a contributory basis. It appeared to many that the federal role should be limited to encouraging other states to follow suit. The question was, how could a federal-state cooperative program be set up so as to minimize the chances that it would be struck down as unconstitutional? Arthur Schlesinger's book, The Coming of the New Deal, describes a meeting in the fall of 1933 which took place in the apartment of Mr. Justice Brandeis. He wasn't present, but his daughter and her husband, Paul and Elizabeth Rauschenbusch, had pulled together a group of liberal businessmen and young New Dealers, including Charles Wiesanski and Thomas H. Elliott of the Labor Department, and Thomas Corcoran. The Rauschenbusches sought to persuade the others of the value of federal legislation that would induce other states to adopt unemployment compensation like Wisconsin's. The structure they proposed, a plan later attributed to Brandeis himself, was a federal payroll tax on employers with a credit for those who were paying to support a state unemployment compensation law. Secretary of Labor Francis Perkins showed an interest in the idea. Elliott and Rauschenbusch drew up a bill which Senator Wagner and Representative Lewis introduced in Congress in February 1934. That legislation did not move. Later that spring, President Roosevelt sent to Congress his message on economic security and established a committee on economic security chaired by Secretary Perkins. Early during the deliberations of that committee, it decided, primarily on the advice of actuarial experts, that old age insurance could not be established on this sort of federal-state cooperative basis. A memorandum prepared for the committee by Alexander Moltroft, dated October 34, considered the constitutionality of a federally administered scheme. This memo concluded that a scheme that involved contributions by employers and employees imposed as a tax, with the employer being directed to withhold the employee's share from wages, would stand the best chance of being sustained against constitutional attack. The memorandum suggested that the contribution should be paid into the Treasury and not set aside as a special trust fund. This memorandum concluded that the tax would be a constitutional tax, an excise tax so far as the employers were concerned, and an income tax as to the employees. Concern with these constitutional questions was not unfounded, as the unprecedented legislation of the Roosevelt administration reached the federal courts in 1935 and 36. It encountered an extremely hostile judiciary. Schlesinger notes that only 28% of the federal judges at the time were Democrats, and he counts 1,600 injunctions issued by federal courts during 35 and 36, preventing federal officials from carrying out federal laws on constitutional grounds. Many of these injunctions were issued in suits brought by stockholders against their own corporations, seeking to prevent the corporation's compliance with the federal statute. The attraction of this cozy arrangement was that it did not include the U.S. as a party, unless the U.S. formally intervened. One of the first pieces of Roosevelt legislation to reach the Supreme Court was the Railroad Retirement Act of 1934. This act established what today we might call a miniature Social Security program for all carriers subject to the Interstate Commerce Act. In an action brought by a large number of railroads, the trial court granted an injunction against enforcement of the act on the grounds that it violated the Constitution. In 1935, the Supreme Court decided that the trial court was correct. The majority decision recited a number of features of the act which it found to be a denial of due process to the carriers. After going through numerous specific objections, the majority's opinion went on to find that the legislation was defective for operating in an area beyond federal power under the Commerce Clause. The four dissenters in that case read the majority opinion as blocking federal legislation in this general area. This decision came down while the Social Security Act was still in Congress, and it provoked a fair degree of attention to the constitutional issues surrounding the provisions of the bill. The heavy tide of decisions striking down New Deal legislation in the lower federal courts and later in 35 and 36 in the Supreme Court caused a great deal of concern for the eventual fate of the Social Security Act and the National Labor Relations Act. In August of 35, Charles Wiesanski was dispatched by President Roosevelt to the Department of Justice to assist in the defense of the labor legislation with which he had been so closely associated at the Labor Department. By the time of the 1936 presidential election, the Supreme Court had struck down 6 major pieces of administration legislation on constitutional grounds. Following the election, the President consulted with some of his advisors about how to deal with the court. He had not had the opportunities his predecessors had of filling a significant number of vacancies. On February 5, 1937, President Roosevelt sent a message to Congress outlining a plan for reorganization of the judiciary. Nominally designed to improve the efficiency of the federal courts, the plan called for the appointment of 1 new justice to the Supreme Court for each justice sitting who was over 70 years of age. A principle which applied to the justices then on the court would have added 6 new seats. The efficiency grounds held the plan open to ridicule by Chief Justice Hughes and others, for there could be little doubt the court's business was being conducted with dispatch. On March 9, 1937, the President made a radio address in which he set aside the pretense and made a frontal attack on the court. But his plan failed to achieve the support among the public or Congress that he'd hoped. The plan was, however, a sufficiently credible threat that it apparently led Chief Justice Hughes and Mr. Justice Roberts to decide that the independence and prestige of the court were more important than their views on the merits of particular cases. And on April 12, 1937, the Supreme Court's decision in NLRB versus Jones & Laughlin Steel Corporation signaled a new alignment on the court. Hughes and Roberts created a majority upholding the National Labor Relations Act. The Social Security Act reached the court at this crucial time. Had it come to the Supreme Court in 1936, its chances would have been quite different. Fortuitously, the taxes on which the unemployment compensation title and the old age title rested did not take effect until January 1 of 1937. The period between enactment in August of 35 and January 1 of 37, that period was required to set in place the complex collection and administrative apparatus required for the new program. Suits challenging the constitutionality of the 2 taxes and the benefit programs resting on them were filed in late 1936. Helvering v. Davis, for example, was filed in November of 36, and it was an action in the classic format, brought by a stockholder against his corporation, seeking an injunction against payment of the tax imposed under the tax title of the Social Security Act. The unemployment compensation tax and benefit title reached the Supreme Court first. A decision by the Fifth Circuit in March upheld those taxes and benefits. The Supreme Court agreed to hear the case, and oral argument took place the very week the Supreme Court decided Jones and Laughlin. Charles Wazansky wrote the government's brief in the unemployment compensation case and took the lead in oral argument. A pair of cases raising the same issues about unemployment compensation and equivalent issues about old age insurance had arisen in the First Circuit. The First Circuit reversed trial court decisions upholding the constitutionality of those programs also early in April. The old age insurance case, Helvering v. Davis, was taken to the Supreme Court, and oral argument was heard on May 5, 1937, with Assistant Attorney General Jackson taking the lead and Wazansky providing support. On May 24, 1937, the Supreme Court upheld both old age insurance and unemployment compensation portions of the Social Security Act. Helvering v. Davis, the old age insurance case, set to rest a number of concerns which were reflected in the initial version of the Act. The decision's treatment of the attack on the rationality of the benefit structure left little doubt that the court would not upset a considered congressional judgment that the income problems of old age required benefits that did not bear so tight a relationship to contribution. Indeed, they did not have to rest on any contribution by the recipient. It also raised doubts whether much, if anything, was gained by having the tax and the benefits formally independent without there being a special fund. Consequently, that decision opened the way for the Social Security amendments of 1939. Freed by Helvering and Davis to express a direct connection between taxes and benefits, Congress did so in the 1939 amendments, employing insurance terminology throughout. It established the Social Security Trust Fund as an earmarking method, created a board of trustees comprised of the chairman of the Social Security Board, the Secretary of the Treasury, and the Secretary of Labor, and called upon that body to report annually to Congress on the operation and status of this fund. The 1939 amendments increased benefit payments for those nearing retirement and delayed a payroll tax increase that the 35 Act had scheduled for 1940. But the most important structural change made in 1939 was the addition of dependence benefits. Originally, the Social Security Act provided only for retirement benefits and to those who did not, in benefits, receive their full contribution, lump sum death benefits. In 1939, acting on the recommendation of the Social Security Board, Congress established secondary benefits, supplemental payments to aged wives of retired workers to, quote, take account of the greater presumptive need of the married couple without requiring investigation of individual need, end of quote. An acute short-term economic and political problem, the extremely low payout and coverage of Social Security during its infancy, motivated enactment of these measures. The improvement of the benefit formula for workers, the basing of that benefit on average earnings rather than full contribution, and the addition of these supplemental benefits.